Which activities automatically trigger strict liability cases? Imagine a situation where someone gets hurt from no fault of their own, and the law steps in to hold the responsible party accountable without needing to prove negligence. That's the essence of strict liability. It applies in specific cases where certain activities are so risky that responsibility is automatic. Let's explore what kinds of activities trigger these cases. First up are defective products. If a product is made with a flaw that makes it unsafe, the manufacturer, distributor, or seller can be held strictly liable if someone gets hurt. These flaws fall into three types: design defects, where the product's design is inherently unsafe; manufacturing defects, where something went wrong during production and made the product dangerous; and failure to warn, where the product lacks proper instructions or warnings about dangers that aren't obvious. The injured person only needs to show the defect existed when the product left the factory and caused the injury. They don't have to prove the company was negligent. Next are wild or dangerous animals. If someone owns a wild animal or a domesticated animal known to be dangerous, they can be held strictly liable if that animal injures someone. This is true even if the owner took precautions or didn't know about the animal's aggressive tendencies. For example, owning an exotic pet like a tiger or lion automatically makes the owner responsible if the animal harms someone. Then there are activities considered abnormally dangerous or ultrahazardous. These are actions that pose a high risk of serious harm and can't be completely prevented even with careful planning. Examples include storing or transporting explosives or hazardous chemicals, or working with dangerous substances that could cause big accidents. Courts look at factors like how likely and severe the harm could be, whether the risk can be eliminated, and how important the activity is to the community. If someone gets hurt during such an activity, they don't need to prove the person was careless. The law automatically holds them responsible. Dog bites are another common example. Many places have laws that make dog owners strictly liable for injuries caused by their dogs, no matter if the owner knew the dog was vicious or not. This means if a dog bites someone, the owner is responsible without needing to prove negligence. In summary, activities that automatically trigger strict liability include manufacturing defective products, owning wild or dangerous animals, engaging in ultra-hazardous activities, and sometimes dog bites. The law aims to protect the public by making sure responsible parties are held accountable for inherently risky conduct or conditions, even if they took all precautions.